I don't think it's a blanket rule either way.
When it comes to allowing religious schools to choose whether to abide by state-mandated restrictions on in-person classes amid the pandemic, Attorney Matthew Manning says there are loopholes.
Even in the law that is cited by Mr. Paxton, the Religious Freedom Act, there is a note that says governments can impose restrictions as long as they're the least restrictive imposition.
The opinion comes after State Attorney General Ken Paxton authored a letter which in part said, quote, when the governor issued orders applicable to public schools, he expressly acknowledged that private schools and institutions have the freedom to make their own decisions, end quote. Manning says extenuating circumstances affect that clause.
I will say that governments do have the ability to put some imposition on religious practice where it is a compelling state interest, and that's clearly what you have here.
However, Paxton says imposing the mandates on private religious schools would violate the U.S. and Texas constitutions and the Texas Religious Freedom Restoration Act. But Manning says there are other factors to consider.
There are students who attend religious schools that don't actually adhere to that religion, right? And in that respect, the question becomes, how do you reconcile their interest in not being in a situation where they could potentially be exposed unreasonably to this virus with the institution's interest in being able to potentially have some kind of religious exercise.
Manning adds that because of the unprecedented nature of the pandemic, only time can tell the likelihood of litigations that may arise out of these types of blanket mandated decisions. Devin Clark, KSAT 12 News.